I want to bring in my guests with me in studio, Deborah Blum, criminal defense attorney, and trial attorney Brad Micklin. Thank you both for being here. So now, before the break, Deborah and I were talking about this juror number 11. What are your thoughts? Are we looking at reversible error if Harvey Weinstein gets convicted?
I think we might be. I was shocked that they left this juror on. Aside from the fact that she lied on the questionnaire, which I think is shocking, that would be cause enough. But the similarity in her topic and the possible motive she has to be there, the information or the gain she may have from the outcome, could taint the jury from beginning to end. So they should have been safer and just dismissed it.
I believe you've seen the questionnaire. We have it, I think, still on our website, courttv.com. It's 14 pages, okay? Getting into law school was easier. It is something. So she had every opportunity to really explain what this novel was about. And there's also this issue of, is she trying to be on this jury for her own personal gain?
Right. And that's where it's most problematic is the defense runs into a problem where they don't know who's coming up. So they have to use their challenge by whomever's put in front of them first. When you run out of your challenges and you find somebody who's so prejudicial, somebody who may have such a conflict in a high-profile case where they already appealed the fact that they don't think they'll get a fair jury here. That was denied. So now they have something to suggest that maybe that is, in fact, the case.
This is a good time to just remind our viewers, Brad, I'm going to do this really quick. So the main complainants of the indictment, there's the 2006 accuser, Mimi Halle, and the 2013 accuser, who's a Jane Doe, and that is the accuser where early on, Ben Brofman, who was Weinstein's, I think, first lawyer, had come out and said there was text messages and emails exchanged. And so before this morning, we had thought, okay, one of the accusers from the complainants, from Annabelle Ashura, from the prior bad act witnesses, one had this ongoing communication. But this morning in court, Damon Tronis, who said dozens and dozens and dozens, and hold on, dozens of emails between Weinstein and individuals, plural. So we're waiting to find out.
I think it's going to play out differently. I think when you look at all recent high-profile sexual assault cases, Bill Cosby, Kellen Winslow, not too far behind all this, they had mistrials, then retrials, then either plea agreements or convictions. And I think given the New York case and the Los Angeles case that's going to follow right behind it, I don't see him walking away with an acquittal on all fronts.
And I know you. It's got to bother you that two of these accuser witnesses, one is from 2004, one is from 2005. I mean, Brad, doesn't that just seem so remote in time for them to be allowed to be brought in?
Especially given the fact that there's several other Mullen witnesses, dozens and dozens of other accusers, that they only have these two that they could actually charge crimes with. And I think that's going to be the strongest piece for the defense to say at closing, that you have to find reasonable doubt if there's only these two, despite everything else that you keep hearing.
Well, I can't wait for this opening statement because so the prosecutors are expected to go an hour and a half. The defense attorneys are expected to go an hour, which is really long, I think, for a defense attorney to give an opening statement. Of course, this maybe warrants such a lengthy opening. Let's listen to Damon Tronis, and this is a preview of what to expect from Mr. Tronis tomorrow morning when he delivers opening statements on behalf of Harvey Weinstein.
It's not a full preclusion. There may be instances where the detectives could be called, for instance, to prove up impeachment or things along those lines. So it wasn't a total preclusion, but it's going to be determined on sort of as the case goes on, I think is a more accurate description of what the judge ruled on.
What are the 7 photographs that are apparently delicate and sensitive?
We don't have any comment. I'd rather just let it stand as it was in court. The government's attempting to introduce certain things into evidence. We're objecting. The judge is going to rule. I don't want to get into all of the facts regarding it. I believe the state did say they were going to attempt to call one of Mr. Weinstein's lawyers, possibly. We would object to that for obvious reasons, attorney-client privilege, things like that. But that decision, I think the court made a ruling regarding some of those decisions which were beneficial for Mr. Weinstein, and regarding how else the state is going to try to introduce it. We're just going to have to wait and see, and we'll object.
But what do you think he was referring to when he said that one of Weinstein's lawyers could possibly testify? Brad, what do you think that could be about?
I think he was talking about the email issues with the PR firm, and it may have been either with his lawyer to the PR firm or the PR firm's lawyer back to him, but there was an email exchange about how Harvey wanted this, either these issues or these cases to be handled, and I think they got a hold of something that's not helpful.
Yeah. So the defense says that this Hollywood culture is part of their defense and the casting couch and all that. Okay. However, we spoke to an accuser from 1978, before there was a Hollywood for Harvey Weinstein, before there was a casting couch. In fact, he was just a concert promoter in Buffalo, New York. Okay, so play this out for me. If the defense tries to use the Hollywood casting couch as you know, part of their defense, would then prosecutors be allowed to bring an accuser from 1978 to rebut that, Brad?
I think it's going to depend on what this person says, but usually I would say no, because, or at least I think it would be an error if they did, because to have a witness that comes from so long before, it's prejudicial to the defendant because they can't obtain confidential information from them. They can't obtain any kind of credibility information. It's all going to be lost.
Brad, what do you think about this idea of like this witness contamination and suggestibility, memory lapses, memory being conflated?
I don't like it for this case because it sounds like, again, we have two accusers. Weinstein's defense is going to be either it didn't happen or they're lying about it. Well, this memory expert is saying that it sounds like her suggestion is they're telling what they believe to be true. It just might be inaccurate. They might have reconstructed it. So then you have to say, well, what they're saying is true to them. It's just not how it really happened. And I think that's confusing. I think they should stick to they had an affair, they had a friendship, here are all the emails. I think this expert really convolutes the issue.
So you think the expert could make this more confusing for the defense?
Yeah, I think it creates an issue to say, well, we don't believe them, but if you do believe them, then it really is just because they don't remember it correctly.
Oh, that's interesting, because I think, listen, I think the defense is trying to set up a star-studded lineup, similar but different to the prosecution. Okay, you guys are going to stick with me. Let me bring in my guest. Still with me, trial attorney Brad Micklin. Thanks for sticking around. Tomorrow is a big day. The defense has a lot on the line. Now, when you're looking at that and you see that these accusers, you know, they really span the globe. We have the New York case, now we have a Los Angeles case, and from the beginning, we have a case, an investigation happening in London. How is it possible that Harvey Weinstein is going to completely get a fair trial? I understand they picked a jury and all that, but how is it even possible that these jurors can keep all of these women you see before you out of their head?
Well, it's not just a question of keeping these, but it's also keeping, as we go through this. I mean, this is going to be months and months of testimony, months of media coverage. So we have to hope that not only do they stick to being impartial now, but as they go home every day, they don't hear more information and get more bias towards the case. But also, the fact that a hearing might not be fair could work in his favor, too. You have more men than women on this jury.
Yes.
You know, they could be prejudiced in the sense of thinking that he's just being targeted because everybody targets, or because, you know, a lot of people comment that nowadays you have to be afraid whenever you're in the room alone with somebody. So it could work to his advantage. It's not likely to do so, but it's always possible that it works to his advantage.
Giving a false memory, thinking it's a true memory. In the court of law, that could be the difference between not guilty and guilty. Brad Micklin, what do you think about that? Because when she just says those words, false memory, delivering it like it's a true memory, that's dangerous.
Right. I think the only thing that the defense gets from this kind of an expert is the biggest hurdle they have is how do you cross-examine multiple people that are victims without looking cold and callous? So here they have a woman who can come in and say, isn't it possible you're just not remembering correctly? Or isn't it possible hearing all these stories has twisted your recollection of it? So it takes the pressure off of the attorneys and the jury looking at Harvey to say, well, he's not callous and cold.
Yeah.
They just don't remember correctly.
Yeah.
So I think it helps them remember. They only need to get one person to have reasonable doubt, and that may help get that one person.
Do you think, though, this whole idea that witnesses can contaminate each other's memories. Like, for instance, I have an incident with Harvey Weinstein where it was, you know, it was something somewhat innocuous. But your incident is more assaultive or harassment. By listening to your incident, could I almost adopt it and make my incident in my memory worse?
I mean, there's a lot of instances where this has become an issue. I mean, we have it when you have children that are being testified. You have it with, you know, recollection of identifications and lineups.
And they're known to be the most suggestible children.
Right. So maybe if you had a case and you have violent abuse, maybe you have a group of people together, and if it's close to the incident, then maybe conversations can twist their recollection. But I've never heard of too many examples that pinpoint this kind of a witness or these kind of victims as having this recollection problem.
Brad, I want to thank you. This is the first time we're meeting. It was great to have you on set. You better come back often.